All right, welcome to another meeting of the Senate Judiciary Committee. Members are trickling in, but we're going to get started right now. If you want to go ahead and call roll, that'd be great.
Senator Crago?
Here.
Senator Crum?
Excused.
Senator Hicks?
Here.
Senator Kolb?
Excused.
Chairman Olson?
Here.
Mr. Chairman, you have a quorum.
Perfect. Senator Nethercott, our first bill is Senate File 116, Anti-Money Laundering.
Good morning, Mr. Chairman. Thank you. Good senators, this bill was brought to you as a result of the work of the Interim Appropriations Committee that had conducted a study on our gaming laws in Wyoming, and that hired consultant provided a series of recommendations. One of those, they had identified that Wyoming did not have an anti-money laundering statute. And so I took the issue up, and you have the bill draft in front of you for that very reason, out of that working group and that recommendation. So good senators, high level, what is money laundering? It is taking illegal proceeds and obfuscating them through a variety of mechanisms and means in order to make the money appear legal or lawful. So this bill draft is adopted really from the New Jersey statute on money laundering. As we know, they have significant history of both organized crime and gambling. And so they know their way around anti-money laundering. And our experts associated with that recommended report had a significant experience in New Jersey, and they knew that that statute had been tested. And so this bill draft in front of you today is based on that law that's been modified to fit with our Wyoming criminal code. So the first page provides definitions for what is utilized typically in a money laundering type scheme. So starting on page 2, the top of the page, derived from, which means obtained directly or indirectly, maintained or realized through. Definition number 2 is property, which is every type of property you can imagine. Why is this so broad? And why are these terms so broad? I know that's your initial instinct of, my goodness, that can mean everything. You're exactly right, because that's how it gets laundered. So it gets illegal proceeds, illegal monies gets laundered through all of the different types of property you see there. And that's how they try to wash it clean. And so that's why, and that's consistent with anti-money laundering statutes, both at the state and federal levels. Here we go down, which is a person is guilty of a money laundering if a person transports or possesses property from the person the person knows or reasonably should know to be derived from criminal activity. I know all of your red flags are peaking when it says reasonably should know. That's too vague. That word reasonably in our criminal code, very common occurrence, and it's understood in the law, and I'll walk through that in a little bit later, but you'll see that throughout this bill draft of knows or reasonably should know. So going on to page 3, directs, organizes, finances, plans, manages, supervises, or controls the transportation of or transactions in property he knows or reasonably should know to be derived from criminal activity. Moving on down, that same kind of behavior is encompassed in there. Paragraph 3, engages in a transaction involving a property the person knows or reasonably should know to be derived from criminal activities, subparagraph A, with the intent to facilitate or promote criminal activity, or B, knowing that the transaction is designed in whole or in part to conceal or disguise the nature, location, source, ownership, or control of the property. So that's really what we know money laundering typically to be. And then under that subsection, also to avoid a transaction reporting requirement under the laws of this state, any other state, or of the United States. Our federal laws are significantly more robust in this area as a result of typically these crimes using interstate commerce in order to facilitate them. And so our federal law enforcement partners usually pick these cases up, and there are federal reporting requirements, which we'll get to later in the bill. Moving through, here's additional definitions on page 4. For purposes of this article, property is known to be derived from criminal activity if the person knows or reasonably should know that the property represents proceeds from some form of criminal activity. It's a felony, punishable of up to 10 years, also consistent with our criminal code, 0 to 10 for most felonies. So moving down to illegal investments penalties, a person is guilty of illegal investments if, with the intent to evade a transaction, you launder the money through a financial institution, is essentially what this is meaning, or you invest it in some other type of financial investment scheme. Moving down, and here we go, and there's this reference to the federal code, which is with the intent to evade a transaction reporting requirement. At the federal level, there's a law called the Suspicious Activity Report, where many of these entities, like casinos, are required to provide to the feds a suspicious activity report, which, when they reasonably should know or they suspect that there is illegal activity afoot, that they provide that activity report under this federal code. Then moving down, causes a financial transaction to occur either through the casino, the check cashier, or other entity subject to the suspicious activity report financial requirements. Moving down onto page 5, there's a lot of different money structuring schemes for how you can take those illegal proceeds and put them into a money structure scheme, which is what this subparagraph 2 relates to. And this particular crime is also a felony, 0 to 10. With that, good senators, happy to stand for questions. I know that was a very quick run through of the bill, but assuming you have questions about some of the language, I'm happy to stand for those.
Senator Hicks?
Yeah, Mr. Chairman, question, when we get to the definition of property, this thing is kind of wanders around in different areas, and is some of this already come out of existing statutes? It was my assumption on there.
Yeah, Mr. Chairman, through you, as indicated, that term property is that broad, and it's intended to be that broad to include all forms of property that is utilized for the purposes of laundering money. And so these schemes, it's much easier to understand the context on the ground of organized crime, right? And so they have phone cards, they have a restaurant, they try to legitimize the illegal money through legitimate means using this form of property, or vice versa, and it goes back and forth. And that's why that is so broad. And that's typical with federal law and the New Jersey law. A failure to have a broad definition of property would then arguably authorize you to use those properties not identified as a tool for money laundering, and that might be considered legal.
Mr. Chairman, if I follow up, and I agree with that, and so we want to capture everything, and it kind of does that when it says anything of value, including, but then we start enumerating a long list of things, and my concern is always when we start to enumerate something and it ends up in a court system and they say, well, if the legislature really would have meant that, they would have spelled that out. And so this is kind of a mixture of trying to be very broad, but then we narrow it down, and I'm still trying to think of the application of how we would launder gas and steam or other power and so we start to narrow that down to those specifics, and I don't understand how you would launder money utilizing electric, gas, and steam. But any thoughts on how we could craft that to get to exactly leave it broad enough and identify all sources of wealth and property without enumerating all of those things that are probably archaic out of statutes?
Senator Nethercott?
Mr. Chairman, great, thank you for the question. I think that's a great question. Curious to hear other legal interpretations about having it be too broad, and it could be void for vagueness on a constitutional challenge, although arguably it's pretty broad right now. I'm not opposed to having property mean anything of value, including real estate, right? I think that's important. I would be fine with that amendment.
And I think you could have, for clarity purposes, you could tangible or intangible personal property, that's fine. And then it's really after that point in time that it starts to delineate the list of real estate, tangible, intangible. Those are your three types of property. There's nothing else that exists in our legal world besides those three types of property, or intellectual property, I guess, could be considered its own category.
Mr. Chairman,
Senator Hicks?
on that, but wouldn't intangible personal property be intellectual
is.
property rights?
Yeah,
That's the way I would read that.
Yeah. Yeah, I'll stand by my original thought. Those are the three types of property.
All right.
Senator Craigo?
Thank you, Mr. Chairman. I guess the question is, I mean, we're really discussing, so I'm not gonna ask the good sponsor a question, but tangible and intangible personal property is defined within statute. I mean, that's in Title 39, and so if we don't have an explicit definition of that here, do we roll over to that? And if so, it's not going to include many of these things within this list. It's a finite list because it's for purposes of taxation. I don't know, I just wonder. Yeah, I don't know where we, probate code as well. I mean, there's some other places where these things are defined. So I don't, there's probably guess I'm a little bit fearful of narrowing this list down too much, but I understand your point.
Any other questions for the senator? Senator Kolb?
Yeah, thank you, Mr. Chairman. Senator Nethercott, I guess I was fascinated by page 2, line 10, the word captured. And what that could be. Could you help me understand that phraseology there? Thank you, Mr. Chairman.
Captured animals?
Mr. Chairman, I interpret it as captured animals such as trapping, hunting, or other captured animals like for fighting.
Mm-hmm. The penalties, Senator Nethercott, did those come directly from the New Jersey law, or did you line those up with Wyoming?
The New Jersey law has a significant tier system associated with the amounts of money involved, going up to 50 years. And so their system is the higher dollar amount, the more severe the penalty. That is not consistent with our law, where we don't focus on trying to game the criminal code by going just under a certain threshold and maybe making it worth the overhead of committing the crime. It's just a felony for the criminal conduct. And depending on the severity of that, our judicial branch then has the discretion to determine appropriate sentence between a range of 0 to 10 years.
Okay. It's kind of what I was thinking. I was thinking it probably was not lifted from them. Other questions for Senator Nethercott? No? All right. Thank you. Move to the room. Do we have any agencies wishing to testify on this bill? Any agencies online? No? Okay, we'll move to general public comment. Welcome, former Senator Ellis,
Thank you.
whose seat I am honored to sit in for the District 8, and big shoes to fill. But thank you for your service to the state of Wyoming.
Thank you, Chairman Olson, private citizen Ellis. Here to represent Cowboy Racing. For those of you who aren't familiar, Cowboy Racing is constructing the Thunder Track racetrack east of in eastern Laramie County, just 10 miles east of Cheyenne. We've been following the Wyoming gaming study, and this is specifically one of the recommendations made in that study was the lack of a anti-money laundering statute. So I'm here today with my colleague Shane Schultz. I'll let him introduce himself.
Shane Schultz with Brownstein on behalf of Cowboy Racing.
Yep, so here, Mr. Chairman, just to lend our support for this bill and appreciate your consideration.
Committee, any questions? All right, thank you. That was easy. Other testimony? Any other testimony? Online? Wow. All right, I'll close public comment. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb. Are there any amendments to this bill?
Mr. Chairman,
Senator Hicks, you want to light up your mic? Nope, he beat you to it, you're fine.
so page 2, I'm going to go back to your original thought. So when we deal with the definition of property, we would keep everything in line 6, 7, and 8, line 8 after property, put a period.
Okay,
For discussion. If I could get a second.
Give me a second, second.
yeah. Second
So it
on
deletes
motions.
everything else below that line. So everything after the period on line 8 after property, everything else is deleted in that line, in that. So line 9, 10, 11, 12, it's where we start to enumerate all those other different types of potential property. So, Mr. Chairman, that would be my first cut.
Okay. My guess is, I don't know how long the New Jersey statute was in place. Do you know, Senator Nethercott? No? I was just thinking, my guess is maybe this list could have been developed over time as they ran into problems and realized that they needed more expansive definition, or they could have just started with some list, I don't know. But I do think anything of value, including real estate, tangible and intangible personal property, really is every type of property that you could envision. I think it's safe.
Mr.
Senator-
Chairman, I think that's what a reasonable person would think.
Senator Crago, do you have any thoughts?
So a little bit of discussion, Mr. Chairman. So if you go to the very end of that particular clause or section, it says, and includes any benefit or interest without reduction for expenses incurred for acquisition, maintenance, or any other purpose. That's not part of the individualized list of items. That, if we're gonna strike everything in between, I think we at least ought to keep that. So maybe that's my friendly amendment proposal.
Chairman, that's a
Senator
very
Hicks?
friendly amendment.
That's friendly? Okay, yeah. Very good. Any other discussion?
That will now read, starting on line 8, it'll say property. And then we'll jump down to line 14 and it'll say, and includes any benefits. Are we all on the same? All right.
I think we're all tracking. Discussion? Further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. Any other amendments to this bill? Senator Kolb?
Yeah, thank you, Mr. Chairman. This is more of a discussion point first.
Oh, that's fine.
I haven't tried to inject such language, but is there a room for language but not limited to? So it would just be more broad? That would be my.
Oh, you're still talking about property?
Yeah, but not limited to, just open it up so we wouldn't, pin ourselves into a corner by specificity.
So to say means anything of value, including but not limited to?
Yes, Mr. Chairman.
Yeah. I like it.
Where do you
Senator
insert
Crago
that?
likes it. Did you,
Mr. Chairman, where's that inserted at?
on line 7, after including, but before real estate? Insert but not limited to.
Got it.
I need a second.
Seconded by Senator Crago. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has passed. Any other amendments? Any discussion? All right. Pierre, will you please do a roll call vote on Senate File 116?
Senator Crago,
Aye.
Senator Crum,
Oh, excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right. Thank you, Senator Nethercott. The next bill for our consideration is Senate File 122, Voyeurism Sex Offender Registration Amendments. For this bill, Pierre, we're gonna go ahead and let Mr. Cost in now. And I think it's Melanie, right? And Melanie. And Senator, my understanding, Cooper, is that you're gonna give us a brief introduction and then we're gonna turn it over to Mr. Costs.
Thank you, Mr. Chairman, that's correct.
All right?
Ed Cooper,
proceed.
Senate District 20. So with me in the House here today is the representative of the Attorney General's office in case I get lost on this 6-word bill. The genesis for this bill was 3 years ago, maybe 21 or 22, I think 21. We brought forward a bill to require registration on the sex offender list for felony voyeurism. But if you look on line 15 of page 1, the verbiage that's struck is if the victim is a minor. So what this bill actually does is say, back to where we intended it, whether the victim is a minor or adult, it still requires registration. So with that, I'm going to ask for Senator Cost to come on and former Senator Cost and give us some history on the bill, and then we'll ask the victim of this particular crime to testify. Thank you.
Very good. Welcome, former Senator Cost.
Well, thank you, Chairman Olson. It's an honor to be here. I'm going to look like I am reading this because I am going to read it so that I don't wander and spend a lot of your time today. First, I'd like to thank you, Chairman Olson, and committee members for allowing me to testify today. In 2021, I was asked to help update a very outdated voyeurism statute. With the help of a number of qualified people, the bill passed and is in statute now. One of the biggest concerns was the difference from a few pictures to a large collection, making the penalties different, thus the felony voyeurism crime. Technology has advanced to the point where a camera with video capabilities can be as small as the eraser on the head of a pencil. That technology continues to advance. With the ability to post the material on the internet compounded with complexity of the crime, thus this felony voyeurism charge was developed. In the original bill, the penalty also stated that if the felony voyeurism crime was involving a minor, then the perpetrator would have to register as a sex offender. In general, we look to create laws to better protect our citizens of the state. In an effort to protect the neighborhood and the community where a perpetrator of a felony voyeurism crime involving a minor might reside, registration was considered necessary. After researching statistics to different forms of voyeurism, it was found that somewhere between 19 and 20% of the perpetrators, when released, return to the same crimes committed or escalate those crimes to a more serious level. Finding this out pointed out a gap in the statute. The protective step that was left out was for the adult victim crime. We can say that the safety of the neighborhood and community are safer only when the perpetrator of the felony crime, where a minor was involved, I said that wrong, can we say that the safety of the neighborhood and community are safer only when the perpetrator of the crime, felony crime, where a minor was involved has to register. The felony crime with regards to the minor is very important, but is the safety of the neighborhood and community still at risk when the adult is the victim? I think both present present, boy, I'll tell you, I'm nervous. I better quit it. I've been in front of you guys before, but not like this.
You're doing great.
I think both the present, the need, present the need for registration. Therefore, we need to change from registration only for the minor to if the perpetrator has committed a felony voyeurism crime against a minor or an adult, registration is required. If there are no questions, I would thank you again for your time. And if there are questions, if I can answer them, I will do my best. If I can't answer them, we have a fine young lady sitting to the right of Senator Cooper that is very capable.
All right, let's start with any questions for Mr. Cost or Senator Cooper. No? All right. Ms. Chambers, do you have anything you want to add?
Thank you, Chairman Olson. Kara Chambers, Wyoming Attorney General's Office, Division of Victim Services. No, I was really here, as always, to answer any questions that come up. My connection to this is that DCI administers the registry, which is part of our agency, so mostly here. You know, I believe you have testimony from a victim who would like to speak, and I would encourage you to hear that directly from them, but any laws that protect victims are something that we keep an eye on.
Senator Culp.
Yeah, thank you, Mr. Chairman. Just have a question. Is this type of crime can it be expunged in the future?
Ms. Chambers.
Chairman Olson, Senator Kolb, generally sex offenses that require registry cannot. There are some circumstances, as you're very aware of, where mistakes happen. The other thing that can happen is depending on the level of registry, because if you're familiar, there are different burdens of registry, different types of registry. Certain levels of registry, a person can request the court to be relieved of that registration duty. So that is maybe more what some people think of, you know, that they could get off the registry. But expungement is not supposed to happen, but I would be naive if I said there aren't the occasional loopholes.
Ms. Chambers, just from your office and what you deal with, I'll say I'm really glad to see this bill, Senator Cooper, because I think unfortunately, oftentimes, at least in the past, based on the way that our statute had been structured and we've had to come back and amend this so much, I think people often don't think of the victim in the same light in a voyeurism case as they do in other sexual assault crimes or sexual crimes. But the reality is that a person subjected to voyeurism goes through a very scarring event and should not be treated any differently, I don't think. So I'm really glad to see this bill. With that, let's go ahead and we've got Melanie on, so let's go ahead and go to Melanie. We'd love to hear from you. Is her microphone on? Melanie, if you want to go ahead and turn your microphone on, we'd love to hear from you. You can't sound like an invitation to.
She's saying it won't let her unmute.
Isn't there a button that you can send that sends an invitation to unmute?
Yes, I did.
Oh, you did? Okay. Looks like it's on your end, Melanie, to unmute.
She's working on it.
Okay. While she's working on that, is there any testimony in the room? Any additional testimony? No? Was there any other testimony online? Anyone else signed up? No?
Chairman, also, if I may.
Yes, go ahead, Ms. Chambers.
Because I am somewhat familiar with perhaps what she may have intended to speak about. One thing that I think is worth noting is that when we have individuals who are sex offenders, they tend not to age out of this crime. And so you heard prior testimony about recidivism rates. And so I do think it's important for people to keep in mind that these do tend to be a group of offenders who tend to escalate and reoffend. Not always, it's certainly not painting a broad brush by that, but I think that is perhaps some of the victim's testimony about her particular offender and maybe some escalation and recidivism.
Very good. Still nothing?
She's saying, she's clicked on the unmute a number of times and it doesn't seem to allow it.
Maybe.
Or audio, I should say.
Maybe someone let her know to leave the room and come back. Maybe try that.
Would she maybe use the phone number and call in rather than?
We could do that, I'm sure.
I hope we can get her testimony. It is pretty valuable.
Did you take her out of the room? Okay. So let's try to unmute now, Melanie.
Mr. Chairman,
Yes.
absent of Melanie's help here, I was wondering if former Senator Cost has an idea on the history that she wants to discuss.
Yeah, it doesn't look like we're gonna get her testimony, unfortunately. Senator Cost, is there anything you wanted to add to the testimony?
Well, without her being able to unmute, I certainly can. Basically, her testimony, because she was a victim, she discovered at the time that the person was being charged, that the voyeurism bill was extremely outdated and thus asked for the assistance to try to update it. Her situation was, at work, there was a gentleman that would put a small camera under the sink.
Hi, I'm so sorry to interrupt. I think I got it working. I'm so sorry.
You got it working, and I was just gonna say, he doesn't sound like a gentleman, Mr. Cost.
I'm so
Thank you
sorry to
very much.
interrupt.
I will definitely agree, but I'll leave it to Melanie. She can
All right,
take over.
Melanie, welcome. We're glad we got you.
Yes, I'm so sorry. I was in my settings and I had to dig around and try to allow my microphone. I clicked that button numerous times and it just didn't want to cooperate, and it was a setting in my phone. So,
All right, go ahead. Tell us what you want us to hear.
all right, thank you so much. First of all, I want to thank everyone for allowing me the opportunity to speak today. I'm here today in favor of the bill that would make those convicted of felony voyeurism required to register as a sex offender, regardless of whether or not the victim, or in my case, victims, are or were minors. I have been directly impacted by voyeurism. Back in 2019, when I worked at a previous place of employment, I had frequently used my lunch breaks to enjoy walks outside. I also used the workplace bathroom to change my clothes before and after my lunch break. One summer day, I had returned from a walk and changed my clothes like I had many times before. And while halfway disrobed, I spotted a web camera-sized recording device located under the sink in the restroom, pointed right at me. And that began the nightmare that has brought me here today. Police uncovered over a year's worth of video recordings, which they equated to over 100,000 captured images. A male coworker had been placing a camera in the women's restroom for years. I ended up having to go down to the police station to identify 3 of my fellow female coworkers using the restroom, and they in turn had to identify me doing the same. To say that this was just an invasion of privacy is a huge understatement. Part of the evidence showed the perpetrator taking mock video and images of himself sitting on the toilet so he could capture the preferred angles and recordings that he wanted to capture. This was not an accidental crime. This was premeditated and malicious. When a person uses a bathroom or a fitting room, they assume they are alone and in a private space. Think of the times that you are in a restroom and you're using the toilet or changing your clothes, especially in a workplace environment or in a public restroom. A level of privacy is expected that we all take for granted. He violated that privacy to the billionth degree, in my opinion. The perpetrator in this case ended up being convicted of 4 felony counts of voyeurism, 1 count for each victim. At the time of his conviction under the current Wyoming law at that time, the punishments for this crime were very minimal with regard to prison time. They had been written before technology existed and certainly didn't cover the plethora of ways that a person can now commit this crime by using recording devices such as video cameras, web cameras, cell phones, etc. Therefore, I feel as though he got a slap on the wrist for his punishments, and he also was not required to register as a sex offender. No matter the age of the victims involved, voyeurism needs to be seen as a crime of a sexual nature, and those that are convicted of felony voyeurism need to be required to register as a sex offender. It is exploitation. This person had been watching me use the toilet for years, as well as 3 of my female coworkers, and had been watching me change my clothes after exercising. He knew my routine and my schedule and used those opportunities to violate me. The person who committed this crime against me ended up serving 2 years in prison, and upon release was required to also serve 2 years of supervised probation. Once he was out of prison and on probation, I was never informed of his whereabouts. I was never informed of his workplace or his current address. If he had been required to register as a sex offender, not only would I have been made aware of his whereabouts for my own safety, but it also would have been for the safety of the community as well. In fact, I heard nothing about him until after he had violated probation and was needing to appear before the judge for sentencing. He not only violated his probation in one way, but in 3 different ways. He did not complete the required sex offender classes. He was also found in possession of pornography, and he was in possession of an internet-capable device. His violation of his probationary time is just further proof that he is in fact a predator and highly likely to reoffend. He was and is a threat to the community. Unfortunately, he was not required to register as a sex offender because that wasn't part of the law that was in place at the time of his conviction. However, I'm hoping today will be the start to a positive change to the voyeurism laws here in Wyoming. Victims of voyeurism deserve more protection and the right to feel safe. This crime can affect anyone at any time. This violation of privacy is not specific to only minors or only women and needs to be viewed as a sexual crime. If a person is attempting to view another person in a space where they are at their most vulnerable, they should be seen as a predator and be registered as such. A person doesn't view another person in a private space like a bathroom without the intent of capturing them in their most vulnerable state, which is without their clothes on. I was targeted. He was waiting for me to leave the restroom so he could grab the camera and view its contents. He wasn't banking on getting caught. What kind of person wants to watch their coworkers use the restroom? His actions were not an accident. They did not happen by coincidence or mistake. They were intentional and they were sexual in nature. He is a predator, and predators will continue to hunt until they found their next prey, and they don't stop after just one opportunity. This crime is happening way more than we realize, and with the amount of technology available and the amount of pornographic materials at everyone's disposal on the internet, this type of crime needs to carry harsher punishments. I do appreciate your time today. I kindly request that we work together to ensure safety and protection for victims of this felony crime and for our communities as a whole. Thank you so much.
Any questions, committee? Melanie, we really thank you for your testimony. sorry that you had to go through what you did go through, but we are glad that you're here trying to advance public policy on this measure that can make it better for future victims. So thank you.
Yes, thank you so much.
Mr. Chairman,
Senator Cooper.
I just wanted to thank you for allowing Melanie to testify in that way. I think it's critical we protect her privacy as we move forward with this bill.
Agreed, thank you. Any other public testimony on this bill? All right, I will close public testimony. Committee, what is your pleasure?
Move the bill.
It's moved by Senator Kolb. Are there any amendments to this bill? Any discussion on this bill? All right. Pierre, will you do a roll call vote of Senate File 122?
Senator Crago,
Aye.
Senator Crum,
Excused?
Senator Hicks left an absentee vote of aye. Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right, Senator Cooper, we'll be there to help you on the floor if you need it. The next bill for our consideration is Senate File 133, Protection of Parental Rights Amendments, and we have Senator Brennan. Welcome to Senate Judiciary.
Thank you, Mr. Chairman, members of the committee. What I have for us today is Senate File number 133. It's the Protection of Parental Rights Amendments. If you'll remember, a year or two ago, we passed the Parental Rights Bill. What we did not have in there was anything giving citizens a civil right of action, and that's really what this bill seeks to do. So if you look on page 1, section 1, Wyoming statute, we create 1-39124. And the basics of the bill really then are on page 2, where it says a person whose parental rights as provided under this section has been infringed or will be infringed in violation of this section may assert the violation or impending violation as a claim or defense in a judicial or administrative proceeding. And it goes on, you guys can read it, but the gist of the bill is that we're giving parents a little bit of teeth to the parental rights bill.
Senator Brennan, just working through the new language here. What the language on the bottom of page 2 reads, has been infringed or will be infringed. What does that mean to you, the will be infringed?
Correct. And it was, so when we went through and in drafting and looking at that and whether it should or shouldn't be in there, the will be infringed is like if there are rules that are being made, like at a, say a school district or something, rules that are being made that would infringe upon these rights.
Are you aware if there are any existing Wyoming statutes creating a cause of action that use similar language to that? Because I don't think I've ever seen anything like that.
I am not.
Okay. Senator Crago, go ahead.
So, couple questions, just lawyer questions, so pardon me up front. So one of the things I'm thinking as I read this language, and I also have the same question about will. So for example, I'm thinking about a DFX action, right? So we're dealing with child custody or something along those lines. right? And then if you go to the next part of your bill on page 3, lines 1, 2, and 3, it says, a violation of this section may assert the violation or impending violation, which, and, we're talking about something in the future, as a claim or defense in a judicial or administrative proceeding. So I'm thinking about if, for example, DFS brings an action against parents, right? For neglect, abuse, et cetera. The way I'm reading this and what we're doing, if it's passed as it's written, we're giving the parents the ability to essentially file a counterclaim within a Title 14 type proceeding. And that scares the heck out of me, to be quite honest. So is that something you were envisioning where we would allow, and this is my first question, I'll get to my second one next, but is that something you're?
No compounded questions.
I know, I'm keeping it simple as I can, sorry, Mr. Chairman. But Senator, is that something you were thinking? Is that something we want to allow? Give us some insight into what your desires are with the bill.
Senator Brennan?
Thank you, Mr. Chairman. Senator Crago. No, that is not what I was thinking with this. And so if we need to amend some of that, we can definitely look at that. I'll be the first to admit that I'm not a lawyer.
Follow-up questions, Senator Crago?
So, thank you, Mr. Chairman. So, and I remember we dealt with, we've been dealing with this type of issue for as long as I've been in the legislature, which is, depending on how you want to look at it, either long or short, 4 years, depends on the day. But one of the questions we also get into on this type of language is, are we actually creating a cause of action against the courts themselves? Because they're not explicitly excluded from this language, right? They are a subdivision of the state. So are we allowing parents to sue judges, courts, et cetera? Because as a lawyer, I would argue that this language also allows that. So is that something you were wanting to do?
Senator Brennan?
No, not necessarily that. What we want to do is just give parents for our parental rights the ability to have there be a cause of action for that. So if you have some
So that's it.
thoughts on that.
At the heart of it, the intent of your bill is for parents to have relief or a cause of action. And at the end of this section on lines, 7 through 10 is really what you want. You want the parent to have a cause of action that may be injunctive relief, declaratory relief, and including compensatory damages, costs, and attorney's fees.
That definitely would be the heart of the bill, I think. I need to look at that,
I think that's really it. Senator Crago?
One last follow-up question, Mr. Chairman. Are we really talking about schools, or are we talking about the other agencies of government? I mean, I think that would help us narrow down, what you're really trying to get at here, because actually within the existing statute, schools sort of have their own little subsection, right? The rest of 14.2206 is, contained within subsection A and B. And then last year we passed subsection C, which dealt exclusively with schools. And so that would also help me as I'm thinking about how to proceed on this particular topic.
Senator Brennan?
Sure. Thank you, Chairman Olson, Senator Crago. What we want is we want parents to be able to, should anything with parental rights be in jeopardy that's in our law, we want there to be a cause of action, I believe.
So agencies and schools, just not the court. Right? If the example given earlier, Department of Family Services, you want to create a cause of action for a parent against the Department of Family Services if a parent believes their rights have been violated.
Can you say that again? Sorry.
You want, if the Department of Family Services has violated parental rights, you want to create a cause of action for a parent to bring that action against the Department of Family Services or a school, just the same as a school.
Correct.
but not the courts. That's kind of that's just an over broadness of the language by drafting error.
Let me gather my thoughts.
Let me ask you this, Senator Brennan, where did this language come from? Did you give the idea to LSO and they drafted it? Or did some other person or entity bring this language to you?
This was from ADF, Alliance Defending Freedom, is where this language came from. And that's why I'm
So possibly,
looking so.
are you aware if this language exists similarly in other states?
I do believe it does.
Is there,
I can find out.
did you bring someone from ADF to testify online to this bill?
I don't think we do have anybody from them, but I will.
Mr. Carpenter wants to testify, but we don't know if Mr. Carpenter is from ADF? He is from ADF.
They
Okay.
didn't show up.
So, and possibly a
We can ask
lawyer,
them.
so maybe we'll
That would be great.
bring him in, and maybe that will answer some of Senator Crago's questions. Mr. Carpenter, welcome.
Yes, thank you.
Yeah,
Mr. Chairman.
Yeah, go ahead and let us know who you are and what you want us to hear. And if you've been listening to some of the questions that have been asked, if you can address those. If not, we can re-ask them.
I have. Thank you and good afternoon, Mr. Chairman and the committee. My name is Jordan Carpenter and I serve as legal counsel for Alliance Defending Freedom. I have been listening and would like to briefly address your questions in order, and then I might read the statement I have prepared.
That would be perfect. Go ahead.
Yes, sir. So the language regarding will be infringed or an impending violation of a right is simply to address the concern that a parent's rights need be violated before they would have standing to sue in court. So it's simply an attempt to address that issue. There is similar language in various religious freedom protection statutes around the country. Sometimes the language is infringed, sometimes it's burdened, sometimes it's is likely to be burdened, sometimes it's will possibly be burdened. And so there are various iterations of that idea, but all of them seek to ensure that citizens' rights don't have to be violated before they gain access to the courts. Secondly, whether the statute would allow a parent to sue a court, that question was definitively answered by the Supreme Court of Wyoming in the case Johnson v. Johnson in 2020, when they said that 14-2-206 does not allow parents to sue courts. And the answer to the third question that I heard and wrote down is that yes, the statute does apply to all of government, it seems my belief that the legislature intended it to apply to all of government, but that subsection C that was added last year seems to take away all doubt that a school hiding information from parents was a violation of this statute.
Any follow-up questions, Senator Crago?
Thank you, Mr. Chairman. So, Mr. Carpenter, so I understand we had a case, which is actually why we're sitting here debating this right now. So we did have a case in the Supreme Court, the Johnson case, where our Supreme Court said that 14-202-206 does not apply to the courts. And we had a lot of back and forth on that last year, which is why we ended up with the section we did, which limited it to schools. My concern is that I think this language in the proposed bill opens that can of worms back up, because there's no limiting language within here. It essentially says any agency of the state. And so that was really my concern. That was my question. I understand that previously the court interpreted the statute to say one thing, but I guess my concern is obviously we would be changing that. And do you have any thoughts about that?
Mr. Carpenter?
Thank you, Mr. Chairman. The way I read the statute is that subsection B applies to all of government, and that it would, or at least the state as defined, and it basically removes the sovereign immunity protections that the state enjoys in general. I view subsection C as, I guess, an expression of the legislature's understanding that a school hiding or obfuscating the communications or disclosures to parents about their children is a violation of that. And that would remove maybe a claim of qualified immunity to say, well, I didn't know that when I hid information from a parent, that it violated the liberty of a parent to the care, custody, and control of his child. So that's the way I read the statute, and I would defer to the Wyoming courts.
Senator Crago?
Follow up, Mr. Chairman. So, Mr. Carpenter, and I think you heard my question to the good senator here, the good sponsor. Are we trying to get at the school situation, or are we trying to, attack a broader problem? Is your organization mostly concerned about being able to enforce the new subsection C? Or are we wanting to be able to enforce all of 14.206, through this new proposed language?
Mr. Carpenter?
Thank you, Mr. Chairman. Senator Crago, I believe we're trying to provide broad protection for the parental right that is granted in Section 206 as a whole. And so I have examples from other states where parents have had their rights violated. It happened to be in the school system where that happened, and their lawsuits were dismissed because their parental rights statute doesn't include a statutory right of action. And so, it just so happens that the state interacts with parents' children most often in the public school setting. And so I think that's probably the most likely place for a violation or for a claim to arise. But I don't see that as being the only place that it could. And I think that understanding the right more broadly is to say that this would elevate the parental right to a top tier right on the same level as a constitutional right. And whether it's a police officer, a school counselor, a DFS worker, or whomever, they can't violate your right to free speech or association or expression, your right to vote. None of these things can be violated by any arm of the state. And so I would ask you to view the language of the bill and the statute as a whole in being in that tradition.
All right, thank you, Mr. Carpenter. You said you had some more written remarks that you wanted to provide us with?
Yeah, I've covered it a little bit, but I would like to just say that the cases that I had were a Florida case where a 12-year-old girl was encouraged by her school counselor to adopt a male identity for an entire semester, despite knowing her parents wouldn't approve of that action. And eventually the girl's despair in leading a double life where she had to be one person at school and one person at home grew to be so much that she attempted to end her own life in the school bathroom. And her parents sought a legal remedy for the violations of their rights here, that they were kept in the dark and then actually lied to. But unfortunately, the school board's attorneys leaned on the fact that there was no right to assert a claim in the statute. This is in Florida. Also in Virginia, a group of parents were surprised to learn their children were being subjected to indoctrinating lesson plans about the roles of race and gender ideology and sexual preferences without their consent. They gathered all of the evidence and presented it. The court also said that the Virginia parental rights statute lacked a private right to assert a claim, and so their claim was dismissed. In both cases, the plaintiffs argued that the legislature would not have deliberately passed a law protecting parental rights without an expectation of its enforcement. After all, what is a right without a remedy? Absent evidence of abuse or neglect, parents should be regarded by the state of Wyoming as the ultimate decision makers of what's best for their children. Simply put, no one knows a child's needs better than that child's parents, who have the right and responsibility to make decisions in the child's best interest without undue government interference.
Mr.
Senate
Carpenter,
file, yes, sir.
can I
Yes, Mr.
pause? I got a question from Senator Craigo.
Thank you, Mr. Chairman. Mr. Carpenter, you just mentioned abuse and neglect. And so the way I read this proposed language, and this was my first question actually, because it causes me the biggest amount of concern. It allows a parent who's accused of abuse or neglect, because that is a judicial/administrative proceeding, to bring a counterclaim against the Department of Family Services as written. And is that what you intend the language to do, or am I misreading it, or do we need to fix that?
Mr. Carpenter?
Thank you, Mr. Chairman. I don't believe that's the intent of the legislation, and I also can point to the other states that have passed a cause of action in conjunction with their parental rights law where that hasn't been the case. Of course, there have been parents that have raised the fundamental right within child welfare context, and in fact, there are several reported cases in Wyoming about this statute. But every time the courts say, no, that's not what this statute is about, and you don't have a fundamental right to not be investigated for child abuse if you have found that there's reasonable cause to be investigated for it, then there's no violation of your fundamental right to direct your child's upbringing by undergoing that process. So this isn't intended to inject more fuel to the fire that in an ongoing court battle regarding child welfare. It's to allow people who don't have access to the court system, who are undergoing violations of their own rights, to have access. Right now, the scales are tilted to make sure that the state has all the power, and we need to make sure that parents also have the right to access the court system.
Senator Craigo?
Follow up, Mr. Chairman.
Please.
Okay, so it's not the intent that it would allow a counterclaim and a DFS action. Can you show me the language in here that prohibits that, or the limiting language, because I can't seem to find it?
Mr. Carpenter?
Thank you, Mr. Chairman. I don't believe it's about the language itself that would limit, because it's not the intent to cordon off any agency of the state from any claims or asserted defenses. On the other hand, DFS, its entire infrastructure is built actually on the concepts that are present in Section 206, that the government does have a compelling interest in preventing or investigating child abuse, stopping child abuse. And so its entire statutory scheme actually plays well with what the interests that are asserted in this statute. And so, again, we wouldn't want to cordon off, because there are examples in other states, not in Wyoming that I found, in other states, though, where the analog to DFS in that state might have breached the public trust in carrying out his or her job by lying on affidavits or taking some kind of extra measures that severely violated the rights of parents. And so we wouldn't want to cordon off that agency from this statute. But then again, like I said, that agency already has access to the court system and brings these actions against parents. And the courts have been very clear that this statute and the language in this statute doesn't alter the way they view the child welfare statutes in Wyoming.
Okay, thank you. Do you have some more remarks that you wanted to continue with, or?
No, thank you, Mr. Chairman.
Perfect. Any other questions for Mr. Carpenter? All right, stay with us because we might come back to you.
Sir.
All right, I went a little out of order. Were there any state agencies or the courts wanting to testify on this? Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Corinne Schmidt. I'm the Director of the Department of Family Services. And we had many of the same questions that have already been asked by Senator Craigo and yourself around where does this law interface with our ability to investigate abuse and neglect. And the language under page 2, line 23, and then again kind of suggested on page 3 is that prospect of what may happen. So if we receive a report of potential abuse or neglect of a child, depending if it meets our threshold, we will start to investigate. So we will go through that investigative process in order to make a determination if abuse or neglect happened. So we either substantiate or unsubstantiate. Now, I'm not an attorney, but from a practical purpose, what I'm curious is if this forward-looking language will be or potentially infringed upon is a claim that could be made during that investigative period, where then there's a potential we could be sued for doing the investigation, and then it bounces up against the best interests of the child conversation as well. And so, I agree 14-2-206 is highly supportive of the work that we already do around parental rights. It's just that anticipation of maybe a substantiation that a parent may have, where then they use this law to be able to really push back on any other opportunity to make a determination of whether the neglect or abuse has happened.
Any questions, committee? All right, I think we're all queuing into the same section of the statute, so we're tracking your concerns.
Thank you.
All right. Any other public testimony? The courts? Ms. Butler?
Mr. Chairman and members of the committee, my name is Lisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. I don't think I had intended to get up and speak, but after the discussion, I thought it was warranted to touch on some of the questions that I think are concerning for the judicial branch. And one of the things that I would like to point out is I agree with the comments from Senator Crago indicating that the new language is incredibly broad, and I think there could be a risk that it would encompass the courts or the judges who are making decisions about things like abuse and neglect actions. And so that is something that we would like to be mindful of. You could have a situation where a claim is made against one judge that's decided by another, which is wholly outside of what judges are supposed to be doing, right? They are given the authority to make those kinds of decisions and given that discretion. The other thing is the Johnson v. Johnson case, I think, is when you're talking about abuse and neglect actions and the authority of the courts, in that case, that was a divorce action. That was not an abuse and neglect case. And so what the court basically said is you cannot extend that 14-206 to divorce actions. But I don't know, especially based on this new language, that whether that same decision would apply to a case that's under Title 14. And so I think that's one piece that we want to be very cognizant of and aware of, is that, judges are charged with the duty and the authority to make decisions in these cases. And so we don't want to put them at risk of having actions brought against them for those decisions. And so, Mr. Chairman, I'd be happy to answer any additional questions if there are.
Are there questions for Ms. Butler? No? All right, thank you. Any other public testimony? Welcome, Ms. McCoy.
Thank you, Chairman Olson. Senators, it's a pleasure to be before you today. My name is Patricia McCoy, and I am here as a mother of four in support of Senate File 0133, the Protection of Parental Rights Amendments. Like many parents in Wyoming, I know that raising our children is both our greatest joy and our responsibility. Every day, we make countless decisions about our children's education, healthcare, and well-being. These aren't just casual choices. They're expressions of our deepest love and commitment to our kids. This bill speaks to me because it gives real protection when government entities overstep into these sacred parental decisions. It provides clear ways for parents like me who have had their rights violated to defend our rights, including the ability to seek help from the courts when needed. Importantly, it ensures that families won't face financial ruin while standing up for their parental rights by allowing recovery of legal costs. I'm not here asking for special privileges or additional authority. I'm simply asking for tools to protect the God-given rights we have as parents, rights that predate any government and that Wyoming law already recognizes. When government entities overstep these boundaries between parent and child, families need a clear path to restore what God and nature have entrusted to us. These aren't just legal rights on paper, they're fundamental, sacred responsibilities. To address the DFS concern, I have personally had DFS used against me with 2 of my 4 children by my ex-husband right here in Wyoming. I had a year and a half of DFS and police visits to my home, false accusations against myself, my character, and my ability to mother my own children. Not once did I blame DFS or the police for doing their jobs. I blamed the person responsible for causing it. I never once thought to sue DFS or the police department for doing their jobs. I could spend hours discussing the flaws within our DFS system in this state, as well as others, when it comes to abuse and neglect cases, but I will just close with this. As a mother, I know that protecting our relationship with our children isn't just about the law, it's about preserving those precious bonds that make families strong. This bill helps ensure that government overreach won't threaten those bonds. I urge you to support SF0133 to protect Wyoming families and our parental rights, and I thank you for your time.
Thank you, Ms. McCoy. Any questions? All right, thank you. Any additional public testimony? Welcome.
Hello, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And while this bill isn't one that has been really on our radar, I've been looking over it quite a bit. And from a law enforcement perspective, it looks very concerning because it seems to open liability up to things that we're not even haven't even considered. Law enforcement works on reports most often of allegations, like in these cases, of child abuse and neglect. And in order to investigate that, we have to ask some questions and talk to people. And we've heard testimony today that sometimes those claims are not honest and accurate, and it might take a little time to get to the bottom of that. So from a law enforcement perspective, we feel like this conflicts with some other protections that might be out there already in these statutes, and puts us in an untenable position. And I'd be happy to answer any questions you might have, Mr. Chairman.
Questions, committee? Thank you, Mr. Thompson.
Thank you.
Any other public testimony? All right, I will close public testimony. Committee, what is your pleasure? Okay. Does anyone want to move this Senate file?
Mr. Chairman, I'll move the bill.
Okay, moved by Senator Hicks. Amendments to this bill. I would entertain an amendment on page 2, line 23 to strike "or will be infringed."
Second.
Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, and then this should have went with that amendment on page 3, line 1, or strike. Line 2, impending violation, strike. That would be consistent with the removal of the language in the previous amendment. Yes, page 3, line 1, strike "or" at the end of the sentence. And then on line 2, strike "impending violation." Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any other amendments? You have a concern about the political subdivision language in the courts?
General discussion.
Oh, sure.
General discussion, Mr. Chairman. I'll be honest, I don't know if we can fix my concerns with the bill sitting here today. Is there a way to do it? Yeah, probably, but I don't think we're gonna wing it, because even taking out the language that we just did as a committee, Mr. Chairman, the language "or defense,"
I have that stricken on a possible amendment as well.
that still creates all sorts of heartburn for me. I mean, if we were just creating a private cause of action that could be asserted at some other point and not as part of an administrative or judicial proceeding, that would clean up a lot of this, but that requires a lot of changing of the language within the bill. I'm still not sure I'm supportive of it, but at least it would take out 90% of the major concerns that we heard about here today, you know, from our courts, from our agencies, from our law enforcement. That would help some, but I don't know if we can do it right here, right now.
Well, we can, Senator Craig, on line 2, we can strike "or defense." And then on, this is page 3, and then on line 5, we can strike "or defense" at the end of the sentence. So we can remove that language entirely from the statute. Senator Craig?
So, Mr. Chairman, that still doesn't prevent a counterclaim. Counterclaim is not a defense. And so you could still have a counterclaim in any type of action. So with the language "a claim," whether it's in an administrative proceeding, it really doesn't fit, is my concern. And the whole problem, I think, with we're trying to shove a private cause of action into a particular part of the statutes where it really doesn't fit. I mean, that's without, I don't know, I mean, it's just, and I don't know how to do that right here today. I'd have to give it some more thought. I mean, do I think it can be done? Absolutely. I'm just not sure I'm gonna be able to fix that, because without taking out the word "claim," you're still allowing a counterclaim in a DFS action. I mean, which you can call it a defense, you can call it a counterclaim. We can get in, you know as well as I do that would still be allowed.
Any other discussion on this Senate file? I will agree with Senator Crago. I have a lot of concerns. I have concerns. I understand the Johnson v. Johnson case, but when we pass a new statute, we reopen the door entirely for judicial interpretation. So I think whether or not this would apply to courts, I think is up in the air. I have the same concerns about the counterclaim being brought. I think that it probably is actually part of the intent of the statute. It's supposed to do that. But I have concerns about it doing that in your standard abuse and neglect case. You could just bring a counterclaim against DFS, who's a party to the action. Whether or not regardless of whether they're a party to the action, actually, so I don't know. I don't know how much of this is salvageable. I can't amend it on the fly either, I guess, is what I'm saying. Other discussion, Senator Kolb?
Yeah, thank you, Mr. Chairman. I think the intent is good. I think it got too broad, and it has too many implications that are too many downsides, that unintended consequences. So I think it is too big of a lift to rewrite this at this point in time.
So we have two options.
Mr. Chairman?
Yes, Senator Hicks.
That may be the case, but just as the process moves forward, I think the bill sponsors have heard those concerns, and I'm inclined to pass this out of here with the amendments that we've put on there. And, you know, it's not incumbent necessarily on us as this committee to address every single issue if we can't, but they've heard the discussion. So I'm inclined to vote this out and give them an opportunity to try to address those on the floor through an amendment. And so, Mr. Chairman, I'm going to be an aye vote on this, and hope the project or the bill proponents can take to heart some of the discussions and maybe help address those if this bill makes it onto the floor.
So I was gonna say the same thing, Senator Brennan, rather than, I'm gonna be an aye vote to move this to the floor as well, because I support the idea and the concept of what you're trying to do. But I hope that you have heard some of our concerns and you'll be, maybe you'll work with, even with your partner in ADF to try to finesse some of the language, to address some of those concerns. Otherwise, I imagine other members of this committee will probably be doing the same thing if they can. So, with that, let's do a roll call vote on Senate File 133.
Senator Crago,
No.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 1 excused, 1 no.
All right, thank you, Senator Brennan. Senator Larson, what do you think? Do you? Yeah, raise your hand if you came to testify on Senate Joint Resolution 5. So I've got 2 people who want to testify on it, and I've got 2 online. So it's up to you. We meet tomorrow at noon. We can just roll it over to tomorrow's meeting if you want, Senator Larson. All right. Okay, we can do that. Then we will stand adjourned for today's meeting and we'll see you tomorrow at noon.